Welcome to the Family Home Journey podcast. I'm your host, Tracy Cheney, and I am so excited to have with us today attorney Vivian Christiansen from the law office of Vivian Christiansen in Ventura. Vivian, welcome.
Thank you. Thank you for having me here today. I'm excited.
I'm excited to have you here. So, Vivi and I have been working together for over a year now on settling an estate for a client that we have in common. So, I've gotten to see firsthand how amazing she is and how much she cares and just really sits and listens to her clients. So, I am very thrilled to have her here. Vivian's office focuses on probate, conservatorship, guardian, trust, and estate matters. And fun fact, Vivian was a paralegal for 15 years before she became an attorney. So she was really in the nitty gritty of it. Um, and I love her approach, the way she helps people, and she's extremely knowledgeable. So thank you, Vivian, for being here with us today.
Sure, of course. Any information I can share, I'm happy to do
And
that.
um, well, I tell you what, there's so much that people don't realize that they don't know about estate planning and preparing their loved ones in advance for their passing, which is going to happen to all of us. So, what I'd like to know is what are a couple of things that are really important to you that people should know?
Well, first of all, the point that you made, it's important to recognize we are going to die. Everybody is going to die. So it's not a matter of if, it's a matter of when. And when that time comes, how well did you prepare for yourself, for your own peace of mind, and for your loved ones? A lot of times people see this creating an estate plan is um, a task that they do to make things easier for their loved ones. What they also don't realize is that if you become incapacitated before you pass away, it's really valuable to yourself and maybe your spouse. So I'd like for people to understand that no matter what their net worth is, it's really important to have a basic plan in place that ensures that your family and your financial goals are met if you become incapacitated and when you die. Death is so certain.
Yeah.
Nobody knows when, nobody knows how. So making plans that you can control is sort of the best way to keep the tension down when that time comes.
I like that, making plans that you can control. Conservatorship, having to go through the courts is so unpleasant and difficult. Can you explain a little bit about what it's like if you don't plan in advance and someone is incapacitated, and you do have to go through conservatorship? What is that process like?
Sure. Conservatorships and guardianships deal with um, more often than not areas where somebody did not have a plan in advance. There are times when you can have a plan and these still come into play, but more often than not, people did not plan in advance, which means they don't have powers of attorney for finances or for healthcare in place to deal with issues when they can no longer deal with them. And then also for guardianships, if you have a minor who is inherits money or is named as a beneficiary on something and they're under 18, they can't manage that. By law, they're deemed not to have the capacity to do that. And so somebody needs to be appointed by the court to do that for them. Sometimes that's a parent, sometimes they don't have parents. If they don't have parents, then often they would need somebody to be appointed by the court to not only manage their finances, but manage their personal needs, where they're going to live, where they're going to go to school, what medical attention they can have, things like that. So overall, conservatorships and guardianships are referred to as protective proceedings. There's somebody that the court is stepping in to protect. And so that court involvement can be quite tedious. It's a very confusing process. It's very hard to fumble through that on your own without having counsel to navigate through that system. It's costly, it's time consuming, and it's very public. So all of the information about your assets and your affairs and your relationships, and all of that is going to be there in the court records and the public court records while somebody is living. So that's we're not talking about a probate which occurs after your death. We're talking about having all that information made publicly available while somebody is living. So it's quite invasive.
Right.
Right. Does that answer your
And
question?
it's not a one it does, and it's not a one court date and done, like, isn't the court involved at periodical times throughout to double check and make sure everything's progressing well?
Yes, Tracy, that's exactly it. So on a conservatorship, um, it's not so much a rule that once you have a conservatorship imposed over an individual, it's a forever process. But most of the time, that's what it turns out to be because the person who's impaired, they're so impaired that they need a person to manage their finances or their healthcare decisions forever for the rest of their life. There are times, I think I've had maybe one in my career, where the individual, it was a traumatic brain injury, and he regained capacity, sorry, he regained capacity, and so that conservatorship was able to terminate. More often than not, though, it's a ongoing throughout the individual's lifetime conservatorship. The process, the tedious part of the process is that because it's court supervised, whoever's appointed to manage those affairs has to periodically report to the court and at times get permission from the court to take particular steps. They can't just have blanket control and management over an incapacitated person's affairs. They would, for some
Providing accounting.
for some issues, though, they need court supervision. So there's a lot of interaction with the court, which is actually what causes the time consuming part of it because you kind of have to fit into the court's calendar, and you can't, if you make a decision one day, you're not probably going to take that action the next day. It's going to be two months or so down the line before you're able to do that. So again, you end up with a conservatorship oftentimes because the person being conserved does not have financial and healthcare powers of attorney. If they did have financial and healthcare powers of attorney, there would absolutely be no need for a guardianship if the person in those documents was willing to act.
Okay. And I think going about getting that done is something that intimidates people, and it's also something that's just easy to push off because it doesn't seem urgent. Um, and I know because you and I have worked together, I've referred clients to you, and I like the way that your office handles it. What do you recommend to people who know they need to get this done? I mean, for one thing, I hope they contact me because I'll refer them to an attorney in their area, or you, and I know you would do the same for them. But if they're just out there and they're like, how do I find an attorney that I can feel comfortable with doing this for me, that I know isn't gonna, be upselling me other things that I don't need, but is gonna take care of everything in a way that's gonna be good for my family? How should they go about looking for someone?
Um, as much as I hate to refer people to the internet to solve their own problems, oftentimes reviewing the issue or the concern that they're having on the internet will help give you a little bit of information about what you're looking for. Familiarize yourself with the terminology used in this area. I know some attorneys are far more sophisticated and they don't necessarily want to let go of the legalese. Our firm has found that where we can, we like to talk simply, explain things simply, um,
Yeah.
use monopoly boards to explain the concepts and just ways that help people understand. So, starting with the internet, getting a general understanding of how it works, what you're looking at, and what you think it may accomplish. But again, only a general understanding. And then maybe talk to a trusted friend, colleague, professional tax preparer, financial advisor. Get a recommendation for like my relationship with Tracy. Get a recommendation for an attorney in your area that you might be comfortable with. That goes a long way if somebody's had a good experience with a particular attorney and you trust that person's judgment. So
Yeah.
definitely the start would be to get the recommendation of somebody that you trust. And then if you just don't know, then or if you don't know anybody or you don't trust anybody's judgment, there's some local referral organizations through local bar associations. So most counties have a local bar
That's a good
association,
tip.
and then they have a lawyer referral service, and then you can ask them what estate planning attorneys are available in your local community. I do recommend having a local attorney. You just want that convenience, you want that peace of mind. After that, it really doesn't matter where you move to, right? Once you have an understanding of what your trust is, it's up and running. It's just a matter of um, keeping in touch with your attorney from time to time so that if something really dramatic does change in your life, you and your attorney can make some changes based on that.
So even if you were to move to a different state after you established your relationship with your attorney, for estate planning purposes, it would be okay to go ahead and stay with your existing attorney?
Yeah, I have found I've been able to maintain most of my relationship with my clients who move out of the area. A lot of them do keep their properties here in California. There are some very state specific issues, but for the most part, your California trust is going to be recognized throughout our country, and most states, title companies, attorneys, however they handle it in their jurisdiction, they can assist you to put your real estate, for example, in the name of your trust. At times we suggest a person that would help them do that, but more often than not, we stick to California and we refer them or guide them to somebody there in their jurisdiction that can help with particular issues.
And to your point about finding someone that you feel comfortable with, I on Thursdays I try to attend court on Zoom, probate court on Zoom as an observer so I can, really get I want to have as good an understanding as I possibly can about what people are going through. And there was an experience a couple Thursdays ago where a family was applying for Hegstead petition, which but for our listeners, if you have a property that's not in the name of the trust, but there was a trust and you want to try to avoid probate, you can file Hegstead petition to try to get the judge to agree, yes, it should have been in the name of the trust so you can avoid probate. Well, in this particular case, the decedents had a couple years ago, they had created a trust. They never put the property in the name of the trust. Apparently, the story that I picked up in court from the family explaining was that he was contacted by a notary. A notary told him, "Oh, I can do all that paperwork for you and I'll file it with the county to put it in the name of the trust." Charged him $3,000 and then nothing ever happened. No documents were produced. It was never put into his name. And sadly, the judge said, "I am so sorry, but there's just not enough evidence here to grant your petition." So now the family has to go through probate anyway. And that's clearly not what the decedent wanted. He was trying to set things up properly. So to your point, finding someone that you trust and feel comfortable with and getting a referral is so important.
It is, and definitely working with an attorney who knows how to deal with those issues and is going to be a little bit more efficient at doing that, and hopefully less likely to fall through the cracks. Sounds like that's what happened.
Yeah, definitely. Yes. Since we have you here, would you feel comfortable sharing a few personal stories of clients that maybe things that happened that, if they had had a estate plan in place, it would have helped them avoid a lot of grief?
Sure, sure. There's lots of those to choose from. Some of the more difficult ones for me to,
Unfortunately, right?
yes, the more difficult ones to deal with are sort of for me to stay focused on because it's frustrating that people have a complete misunderstanding. If you're married, your spouse doesn't automatically have the right to sign your name, right? To manage your all of the assets. Um, and so if there's no estate plan in place, no powers of attorney, no trust or otherwise, if one spouse becomes incapacitated, so gets in a car accident, has a stroke or something, the other spouse can't just automatically pick up and start managing all of the finances. if, for example, the impaired spouse had an employee or an employer retirement plan or pension, and the injuries pushed that person into an early retirement. This well spouse doesn't have the right to just sign their name to elect pension distributions or retirement plan distributions or healthcare, anything related to their retirement plans. So it's really sad because obviously their life continues, and so all of a sudden, because one spouse became incapacitated, everything in their life changes. You lose that companionship, that friendship, you become the caretaker most of the time. And now you're saddled with having to manage all of the finances and navigate through these issues you thought you'd be navigating through together in a happy retirement time. So I have had a case
Mhm.
that the um, the well spouse had to go to court and get a conservatorship because they had not done their estate planning, and she could not sign her husband's name on any of those IRA or any other type of a retirement type accounts. Sure, she had control of all of the community property, as you know, all each spouse has the ability to manage and control community property. But that's not true with real estate. So, for her to be able to sell a house and buy a new one that's suitable for their needs, um, she had to go to court and get a conservatorship. So, there are issues that a well spouse cannot address if his or her spouse becomes incapacitated, and those are really sad because um, I just explained conservatorships are expensive, they're time consuming, so it's costly. It takes a lot. The legal fees and the court process just takes a lot out of a family's budget, maybe that they did not have. It's time consuming, and so that's frustrating. They're trying to manage the health issues of a loved one, and now they're being distracted by this very complicated legal process, and it doesn't move very quickly. It just
Right.
doesn't. And now it's also public, and so everybody knows about their affairs and their finances and the ill spouse's condition and everything. So
Right.
it is really sad. People believe that just because they're married, just because they've been married forever, even that they're automatically going to be able to have that control, and that's not the case. So it's really important for incapacity to have powers of attorney in place.
Right.
Um,
Selling the house is something that people really don't think about. They
yes,
think that they can because it's community property.
correct.
And
Well,
I
and
I've
then
had people that I've begged, like, please just put a power of attorney in place.
I think it's just a lack of understanding. There's, like I said, some broad misunderstanding that you're married, you're one, you each can manage each other's
Yeah.
finances and separately, right? We have joint checking accounts, and we don't both need to sign the checks. So they just assume every account or asset is going to be able to be managed that way. And that's not the case. And oftentimes, if there's an unexpected health crisis with one spouse, a lot of times they are looking to sell. They're looking to sell so that they could move their family closer to more support. They're looking to sell so that they can find a one story instead of a two-story to meet their needs. There's just various reasons why broad authority is needed so that one spouse can focus on the needs of the other and not have to be distracted by a conservatorship proceeding. So that can be difficult.
Absolutely.
So conservatorships are often the most emotional type matters that we're dealing with because people are juggling all of those issues while they have someone who's there living that's depending on them. But then there are times when we have some of these difficult issues that occur afterward. So we have had, as you know, situations where somebody passes away, the family keeps doing what they're doing, somebody keeps paying the property taxes on a house, and before you know it, 20 years later, somebody else passes away and now they realize they need to sell the house. Well, we have to go back to that first death oftentimes and deal with that person's estate, and then look to the next death and figure out what we're doing in that person's estate. And so what happens is ignoring the fact that there are issues that arise when somebody passes away doesn't eliminate them. It just defers them. And sometimes they get compoundedly more difficult. So, um, I've
Oh,
had
yeah, we're working on one
numerous.
together right now
Yes.
that's like that.
And I've had numerous ones like that where, it's great that families support families, but when a homeowner passes away and family members continue to live in the house and think they could just keep doing that, they can, from a practical standpoint, they can, but from a legal standpoint, that property is now owned by an estate and needs to be addressed, and the path to address it won't change. It just kicks that can down the road. And then almost always, in the handful of times I've dealt with these sort of old estate double probates, it gets more and more complicated, and the family dynamics get more and more difficult. So better to stay on top of things as they occur and
Yeah.
clean it up, and then deal with it and make the decisions, move forward, and go through life solving problems as you
Yes,
go.
as it comes.
Mhm.
Yeah, the family dynamics can be intense. And then also when it's one that's been delayed for so long, your capital gains tax consequences can get a little crazy.
Correct. Correct. Yeah. I mean, there's a lot of examples of those issues. There's obviously the double probate is unfortunate when that happens, when you have a post deceased heir or beneficiary. And as you mentioned, capital gains, because that property, more than likely, if you get sold 20 years later, that's another issue you're dealing with. But the newer one that we have is the property tax issue, because ever since Proposition 19, it affects whether we'll be able to keep property taxes the same as that it transfers between parents and children. And there's definitive timeframes that the assessors are enforcing on that. And so if you delay, then we can't help with that. We can't seem to keep the property taxes the
Right.
same, because they're really enforcing that 1 year issue.
No, so then they have to go back and pay these back property taxes
Eventually, the
because
county
they
will
should
do
have
that.
been
Yes.
reassessed.
Correct. Correct.
Yeah.
So all of those are unexpected issues that we just have to identify and deal with when we're faced with a situation like the one that you and I are dealing with.
Yeah. Would you comment a little bit? So Prop 19 is something that I talk to people a lot about. And basically, for those of you who are listening, Prop 19 was passed, I think, back in 2019. If I try to remember
I think
exactly
it
what
was
it
in
was.
2020. The California voters passed that in, I believe, 2020. And
Okay.
it came into effect at the beginning of 2021.
Okay. 2021. And it changed things in a big way, the way that parents and grandparents pass properties down. Um, you used to be able to pass property down without property taxes being reassessed. Um, you had a lot more grace on that,
Correct. Correct.
and now it's
The
very narrow.
Prop 13 was extended, and that is the low property tax basis of the person who owns the house. That number used to, but no longer, was extended for other real estate, not just a primary residence, up to $1 million in assessed value. That's gone with Prop 19, so that doesn't happen. There's a few limited exceptions related to our ag land and stuff like that. But the one that did stay was that you could transfer real property between parents and children as long as it's the primary residence. So that did exist before, but now it's a two-prong test, and it has to be the primary residence of the parent or child, and it has to become the primary residence of the parent or child within 1 year of the transfer. So basically 1 year of the death. And so what's changed on that is that it didn't used to have to be the recipient's primary residence. It just had to be the parent's, for example, primary residence. And so once that unlimited valued property was determined to be the parent's primary residence, the children, even numerous children, could inherit it and convert it to a rental and continue to keep the Proposition 13 basis from their parents going forward. But that changed, and now it has to be used as a primary residence. And if it is not, then it will be reassessed as if you just bought that property that day. So the property taxes in
Right.
that
So
situation
huge
almost always go up.
implications for generational wealth.
Yeah, and property taxes are never going to go down. Once they go up, um, you can't ever get them back down. So it does
Right.
greatly impact the cash flow of property.
Sorry, I didn't mean to interrupt. I would love to ask you this question because I hear this all the time. People ask me, "Well, shouldn't I just put my child on title so that when I pass away, it's not a transfer?" And I know that has big capital gains implications. I'd love to hear what you have to say about that.
So there are a lot of reasons why that's not a good idea. But a few of them would be, um, the first one is that you mentioned capital gain. And so technically, at least under current tax law, when somebody passes away, the assets that they own, um, and up to the percent that they own, generally get a change in income tax basis when they pass away. So what that means in layman terms is capital gain in those persons, real property investments and other capital assets is just eliminated. It just goes away. So if a parent paid $100,000 for a house and they pass away when it was worth $1 million, the child or children that inherit it get it at the $1 million basis so they can turn around and immediately sell it and not have to pay a dime of capital gain. So basically in that scenario, the 900,000 between the 100 that the parent paid for it and the $1 million it was worth when they passed away and it was sold, that $900,000 in capital gain disappeared, was eliminated. And that comes because
But only if they
the
inherit.
person who passed away 100% owned that property. So if instead they have one child and they think, well, my estate plan is going to be joint tenancy, and they add their child on as a joint tenant, then in theory, the joint tenant has 50%, each joint tenant has 50%. So when the parent passes away, the capital gain is only eliminated on their half. So the remaining $450,000 in capital gain is still inherent in that property. And so if it were in the same scenario, if it were immediately sold, there'd still be capital gain because the child whose name was untitled did not get a change in income tax basis. They got the $50,000 that came with half of going on joint tenancy title. So,
Okay.
that's one reason that you mentioned the capital gain issue. The other is for creditors. So really control your children. If there's anything I've learned in life. And so if they do something and they get sued and they are listed on title to your house, that is fair game. So you don't want to get in the middle of your children's creditors or judgment creditors in that situation. So it's probably wouldn't be the best idea.
That is really good point. So the best thing, get a proper estate plan, have a trust in place that names the trustee and, what will happen to the property when you pass away.
Right. Yeah. So the best part about doing an estate plan in a very simple situation, like, well, all I want is my house to go to my child or children or whoever. Um, Remember, in most living trusts, the idea is they're revocable. And so you can change them throughout your life based on the circumstances. And so in a perfect world, our children will survive us and we leave our house, one house to our three children. And the trust says that. But we don't live in a perfect world. And so what if one of those children were to pass away beforehand? What do we want to happen? So if you added all three children as a joint tenant, then you have now a deceased co-owner and their share just as a joint tenant is just going to disappear. Well, maybe you didn't want that. A lot of my clients think, well, if one of my children passes away, then I would want that child's children, so my grandchildren from them, to have their share because that's what would happen naturally. If they had survived me, they would inherit it. If they inherited it when they died, they would turn around and give it to their kids. Well, they lost their parents, so I'm just going to go make that flow happen. So that's what oftentimes happens in a trust. And so if for some reason that's not what you want, It's revocable. You come back and change it. Oh, I hate to report my child passed away. I feel differently about my grandchildren now. This is what I want to happen instead. You have the flexibility of doing that. And you don't really have the flexibility of telling everybody to give back the part of your house, so title on your house so that you can change your mind and give it to somebody else. They're probably not going to voluntarily do that. So if you own it
That's a really
100%
good
and
point because they would have to want to. They would have to
correct,
agree to that.
correct. So instead, if you have it 100% owned by your trust, the trust is amendable by you and you can make all those changes. So if they don't behave one day and you change your mind about them, then change your trust.
Right. Yeah, no, in all seriousness, that's exactly people need to have their trusts reviewed. Anytime you have a major change, life change, but it's a good idea to just have it reviewed, even if nothing's changed in, say, 5 years, have it reviewed anyway. Just make
Right.
sure
Well,
it
even if
still
yes, yes.
has
Even if your
things handled the way
family
you would want them to be.
that's correct. Even if your family doesn't change, your situation doesn't change, you don't have something tragic that happened in that 5-year time period, the laws might change, right? So there may be something that we can do to tweak your estate plan to make it suit your needs um, better going forward.
That's a great point. I don't think people think about that either. Oh, nothing's changed in my life, but laws have changed. We could make this estate plan better for you.
Correct.
Wonderful. Well, Vivian, before we sign up, is there anything else you'd like to share with our listeners?
I would say I know it's a really hard step to take to face your mortality and have a conversation with your professional colleagues, your neighbors, your family about your end of life plans or what might happen if you become incapacitated. Just encourage those conversations, just to get you thinking about where you should be going with that. And then hopefully that ends up placing you at some mine or some other attorney's conference room so that you can hear exactly what is important and should be done and maybe give that some thought. I know it's not easy to take that first step, but you should and not put it off. I
Yeah.
can't tell you how many times I've had people sit in my conference room and a trust has become irrevocable. And they said, well, that's not what they wanted. They've been talking for months or years or whatever about changing it, and they just never did. So it is important
Right.
just to sort of seize the day and if it's on your mind, get it off of your mind, and then you'll feel better about it. I'm sure of it.
Yeah. Right. Not procrastinating is so very important. And I think also bringing adult children into the conversation, and even, I've sat with you in the conference room while you had a meeting with my client, and he brought his adult daughter with him to help him through all of that, and just open the communication, and it's just better that way.
Most of the time it is better. Yes. I have found that if
Yeah.
a family unit is strong and supportive of each other, having a second set of ears is not a bad idea for sure.
Right. Well, Vivian, I want to thank you so much for being here today.
You're very
And
well.
for all of you listening, if you have any questions, please put them in the chat. And I'll have Vivian's website and contact information in the show notes. I believe it's attorneybythesea.com.
It is. It is. That's our website, attorneybythesea.com.
Okay. And Vivian's office is located in Ventura, California. She does help. She does meet with clients over Zoom. So if you wanted to meet with Vivian, I'm sure that can be arranged. Vivian, thank you so much for your time today. I really
Pleasure.
appreciate you being here with us.
Thank you for this opportunity. I really
Okay.
do think it's important that people
All
think about
right.
these issues, and I'm glad that you're making efforts to get this word out here. Okay.
Thank Thank you. And everybody, we will see you next time on the Family Home Journey. Have a great day.